Good morning, good afternoon, everyone. Thank you for taking time to come in and follow this session. First, I would like to thank each of our speakers and guest of honors for taking part in this talk, and the quality and caliber of speakers is really outstanding. I want also to acknowledge for the first time the presence of the Dean of the School of Law at the University of Salaam. You are most welcome. And also to thank everyone who has made it this morning or afternoon to attend the talk. And I hope you are looking forward to the discussions as much as I am. Again, welcome to the 6th Chilean German-Tanzanian Legal Talk. And today's topic will focus on corporate social responsibility and responsible conduct. Usually we are used to the protection and promotion of human rights as a duty of the state, but there has been a growing practice in which companies commit to protect and promote human rights through their CSR policies. Today's topic will examine the potential of the human rights clauses in voluntary CSR policies to promote human rights. And the discussions will reveal that although enhancement of human rights is a consequential presumption, the absence of either an international or a regional legal instrument imposing the duty to protect and promote human rights on companies makes the realization and enforcement of such promises impossible. Furthermore, the speakers will point out that even the existing municipal laws on CSR do not impose a human rights obligation on companies upon which they apply. So I really invite you to follow this talk with interest. And once again, thank you for our learned speakers for giving this time today to elaborate more on these practices from different jurisdiction perspectives. On today's agenda, we will have welcome speeches along with presentation from our speakers. Before we get started, just allow me to share some few housekeeping. Please turn off your microphone when you are not speaking. If you have any questions or comments, use the chat box to post them, and know that the session will be recorded and will be made available to you all after. Now it's time to move to our welcome speeches. I would like to welcome Professor Dr. Toko Kaime, Head of the Chair of African Legal Studies at the University of Bayreuth. Welcome.
All right, thank you, Ange-Doreen, and thanks for all the efforts alongside our other colleagues in making this possible. I would like to welcome all of you to this CGT talk. We're really honored that our guest speakers are able to make the time for us and to share the perspectives on the topic that is before us. I'm not going to say too many words, and just to acknowledge that these efforts are part of our ongoing collaboration, and we value these interactions very, very much. I am looking forward to the next minutes as we listen to what our guests have got to say. Thank you.
Thank you very much, Prof. I would like now to welcome Dr. Sosten Francis Materu, Dean of School of Law at the University of Dar es Salaam, Tanzania. Doctor, the floor is yours.
Thank you very much. Good afternoon and good morning, all of you. It's my pleasure to be participating in this interesting talk, and also to welcome, as Professor Toko said, all participants to this particular discussion. And I'm also very happy to be participating for the first time, although my participation is going to be short. As I said, I have another meeting after some few minutes. But I have noted that the topic of the discussion is something very unique, and especially in the African context, in my view, very topical now that we have a lot of issues on CSR which are coming up, although I must admit they're not very well. Discussion today is going to enlighten us on how to go about these issues. And also I'm happy that we're going to hear from the experts on the area, knowing that the speakers are...
I think we lost you. As we wait, we can have Dr. Ines Ratio, and then we will come back to Dr. Matero. Welcome, Ines.
Many thanks, Angie. Many thanks to our speakers, to our organizers, to our partners, to my colleagues and Cortelius again for pushing this and for giving it this talk a continuity. I'm saying hello from Santiago de Chile, from the Heidelberg Centre Latin America of Heidelberg University. And it's a pleasure to be here again celebrating our 6th legal talk. We've been dealing with topics such as indigenous rights, constitutionalism, climate change, or today, corporate social responsibility in relation to human rights. So I think up to the moment, the 3 national legal talks have been a success also, as also in relation to the topics we are dealing about, which are indeed hot topics with a lot of perspective also for research if we look into the future. I think we can highlight maybe 3 outcomes of what we have been doing together up to now, and what we are hopefully continuing also together. We've been able to join 3 countries which are very far apart, but not only 3 countries, 4 institutions, and I am happy to see that we are more and more incorporating also colleagues from different universities, as is, for example, Professor Schönsteiner from the Universidad Diego Portales here in Chile. I think it is also very important, as I say, together with these 2 outcomes, a 3rd one, which is the fact that you have been able to generate a forum for debate, but also for professional updating, so to say, for established researchers, but also for young researchers, for early career researchers who want to talk about topics which are really hot, as I said, within the law studies, but also in the sense of promoting these kind of platforms as some sort of lifelong learning measures. We are doing a sustainable exchange. This is a sustainable platform. We've been doing this for over 2 years now, and it's been a very fruitful exchange as far as I can judge as a non-expert, but as a person who's working in the international cooperation field. I think, as I say, it's been a fruitful exchange with peers and with other experts. I wish you a successful exchange. Many thanks again. Many thanks, Angie Irakosi, also for the moderation today. To the German Academic Exchange Service, always for accompanying us and for supporting us. And I really look forward not to today only, but also to the 7th talk. Many thanks.
Thank you very much, Dr. Ines. I would like now to welcome Rodrigo Dominguez from the International Affairs Faculty of Law at the University of Chile. Welcome.
Thank you very much, Ange. Well, hello, good morning, good afternoon to everyone. I am Rodrigo Dominguez, coming from the International Affairs Office at the Faculty of Law in Universidad de Chile. I want to especially thank Sven for inviting me here. I am really happy to be present in this instance in behalf of our institution. I want to thank also all the institutions that are making this possible, the DAD, Heidelberg Institute and University, Bayreuth, Salaam University, and I think this is going to be, well, it's being because it's the 6th legal talk, a really profitable conversation about an important topic that has ramifications in a lot of areas in the society. For us as Universidad de Chile is really important. We are really happy to be working with German institutions as we have done in the past, but also we are extremely happy to be working with a university from Tanzania, receiving some really interesting legal talks from professors from Africa, especially Tanzania. Maybe the pandemic was this opportunity we had to make these encounters and relations easier for us and have professors from 3 really different continents and regions in this world to be discussing and looking forward for obtaining some interesting conclusions about these legal topics. And I wish you everyone, especially the speakers, a lot of luck for this instance. I want to excuse myself because I will have to leave at 10 for an important meeting I have. But I want to thank you again and wish you all the best. Thank you.
Thank you. Thank you very much, Rodrigo. Together with Sven, we will be your moderators. And I would like quickly to introduce our first speaker, Dr. Shayo. He's head of department and senior lecturer at the Department of Economic Law. He joined the School of Law in 2005 as an assistant lecturer and has a Bachelor of Law degree from the University of Dar es Salaam, a Master of Law degree in 2004 from the University of Dar es Salaam. He also have a Master of Law in Germany laws and Doctor of Laws from the University of Constance in Germany. His areas of specialization include the laws of business association, corporate governance and corporate social responsibility, competition law, capital market and securities law, and tax law. He is also an advocate of High Court of Tanzania, Commissioner for Oath and Notary Public. He is a member of Tanganyika Law Society and East Africa Law Society as well. Dr. Shayo was the coordinator of an interdisciplinary research project on regional integration in Africa, a joint project which involved the University of Dar es Salaam, Tanzania, and the University of Bayreuth, Germany in 2017, 2018. And currently he is a member of the Africa Multiple Cluster Center of Excellence of the University of Bayreuth under the research section affiliation, researching under the project of social responsibility. He's going to share his thought on the corporate responsibility to respect human rights and from a case study of Tanzania. Welcome, Doctor. You can share your presentation and start your presentation as well. You have to unmute yourself.
Thank you very much, Doreen. I don't know if you can see my
We can see
screen.
it clearly. We can see it.
Very clear?
Yes, very.
All right. Well, I have a lot to talk about, but I will try to restrain myself to the 10 minutes that I've been given. Because my talk, what I'm going to be saying is that corporate social responsibility can be an instrument, could be used as an instrument to enhance human rights. Now, I have first to go into the dimensions of corporate social responsibility in Tanzania, and then see if really this is going to be something that can be realized under the circumstances. As you can see, Tanzania is a country that is located in East Africa, just south of Equator. You know, the area is, as you can read, politically, Tanzania is a united republic. There's a union between Tanzania mainland and Zanzibar, but before it was Tanganyika. I will be presenting right away on the side of Tanzania mainland. That's the essence of saying this, not Zanzibar, because we are united only on 22 matters, and companies, establishment, and regulation is not one of the union matters. That's the reason why I have excluded Zanzibar. The economy of Tanzania is a lower middle income country, and these are the statistics which are not very recent, but to 2020 that I could find reliable. The primary activities in the country, you will see we have agriculture, we have fishing, we have mining, and all this contributes about 23% of the GDP. Secondary activities, we have industries and construction that accounts for about 37% of the GDP. And the tertiary activities, where we have banking, retail, tourism, accounting for about 40% of the GDP. So therefore, at the end of the day, the companies that we're going to be talking about are going to be companies from these particular areas. Now, as CSR, I'm not going to go into the discussions about the definition because the definition is going to be quite complicated, and we don't have, as I could say up to now, a definition that has been accepted throughout the world. And in Tanzania also, we don't have a definition that we can say this is accepted definition in the world. So I'm not going to go into that definition aspects, but I'll go right away into the subject matter. There are justifications, reasons why we need CSR in Tanzania. The research has shown many instances that actually justifies the need for CSR in Tanzania. For instance, we have the poverty rates, which are quite high. I'm not going to go into the statistics. We have poor environmental practices as elsewhere, but of course more in the mining areas where it has been really, there has been an echo. We have poor provision of public and social services. Just to name, we have, for instance, education, healthcare, and water infrastructure is not that very good. So companies could come in, and we have adherence to human rights. Now that the topic, throughout there has been cries, but of course, in this particular case, we are looking at the companies as being perhaps moving away from what we have considered them as the human rights violators into now the human rights proponents. So we will see if it works. And then we have issues of corruption, and we're looking at companies as being also one of the parties that participates in the corruptions. So we have also a poor pursuit of the sustainable development goals. This is an area where companies also could come in and pursue them, and so forth and so forth. The companies have also issues with their remuneration in terms of fairness in their payments, and so forth. The list could go on in as far as justification, if you read the researches coming from Tanzania concerned. But of course, in the area of the corporate governance and management of companies themselves, there are justifications that we still need a CSR itself. I mean, there's corporate responsibility as an aspect that is affecting companies. There's non-accountability. Of course, there is an issue of disregard to a long-term success of companies. The companies looking at the short-term profits and, of course, not looking at the far end. There is also a disregard of stakeholders' issues in most companies. Also, the employees are not really so much happy. Environmental issues are not receiving enough attention. There are issues of suppliers, customers, and of course the society in general. So if we are to list the justification from the company point of view, we have good reasons why we need corporate social responsibility to be an important aspect in Tanzania. The status quo of the corporate social responsibility in Tanzania now, you will see that there are so many companies now taking CSR on board. Okay, some of them are big companies, okay, medium companies, small companies. Okay, but of course, the leading practice, I mean, the leading companies in this practice, you will see you have the mining companies, telecommunication companies, and banking companies. These are the ones which have even come up with the publication of CSR sustainability reports. And then we have also the issue of the projects that are common, or programs which are common for CSR in Tanzania. Many of the companies are on the area of education, women empowerment, health services, offering sponsorships to various occasions, and then, of course, assisting the poor. And if you go to the forms that we find in Tanzania right now, we have a wide range of forms of CSR in Tanzania. We have the mandatory regime, we have the semi-regulated regime, and then we have the purely voluntary CSR regime, which accounts for a bigger part of the CSR in Tanzania. I will not go into the history quite detailed, but of course, I will just give a cursory talk that if we go to the CSR in the modern sense, we see it emerging in the years after 1985. And of course, as a matter of the open market economy that came with the privatization of the public parastatals, which were formerly owned by the government under the socialist system that was there since 1967 to 1985. Before that, of course, you take note of the fact that Tanzania gained her independence in 1961. And of course, between 61 and 67, the system was not very stable, but it was looking for a direction. And in 1967, it took a direction to the socialist side. So if we talk of the historical perspective, the CSR in its modern form, then you see it coming in the 1985 and thereafter. There are phases through which it has gone. First, it came as a practice for the privatized industries, privatized the public corporations. By then, during privatization, there was a hidden kind of an agenda behind the tables for approving those investors who are interested in purchasing the public corporations, they were required to show what they can do more than just pursuing their profits. So they came up with a term that we also do CSR. So during the vetting of the contracts for purchase, an item on CSR was also considered, but of course it was an internal mechanism. So that's why many of the CSR programs you will see started with the privatized corporations. And in most cases, of course, in the mining area, you will see that this became quite prominent, whereby the mining companies came up with aspects of saying, okay, fine, we will develop the local communities. So we will provide public and social services where they are not available, in addition to those you get from the state. So in a way, they were looking for a way to be accepted, but of course, that's how it started. Then it came into the time when the practice was being advocated for by the non-government organizations and civil society organizations, and also the government came up with some policies, policy instruments, but of course, which we are just mentioning, that the companies also will do CSR. So that phase ended up sometime later. Of course, for the mining companies, for instance, until 2017, the practice was purely voluntary, but of course, there was no law that was catering for CSR. Then come 2017, then the first legislation, the first legislation in the mining area appeared. But of course, one would say this legislation was not the first one, because it's amending the Mining Act in the year 2017, but at the same time in 2015, already there had been some instruments that were in place. So in 2015, as we will see later, the legal framework, you will find that there was a law on the Petroleum Act, which was already making it mandatory for the companies in the extractive industry to adopt a CSR. Now, I will come to that, but now let's see the interpretation of the practices that I just explained. From the status quo, we can see that the CSR is treated as a mere philanthropy. The companies providing social and public services by way of donations, and they consider this to be the only CSR they can do. The companies adopt CSR to obtain better reputation as usual. Of course, by this, they are considered to be more responsible than other companies which are not doing CSR. But of course, at the end of the day, if you look at it critically, there's a misuse and abuse of the CSR. Some companies with very good CSR reports, especially in the mining sector, we have seen, are at the same time reported or accused of environmental and human rights abuses. We have situations where this has revealed itself. And also the CSR is now narrowly interpreted as giving back to the society. This is what most of the companies doing CSR will tell you. This CSR is about giving back to the society. And if you look at the way they give back, you see it's only the donations. And this has been what other authors have considered to be a CSR tokenism, just a little bit, and then which does not really correspond to what should have been the broader spectrum of the CSR. the CSR is focusing on the marketing and the market growth as a target of the CSR. The companies are interested into making a good business, but of course, nothing in terms of saying they're being responsible. That's the best interpretation you can have. For the companies which are doing mandatory CSR, most of them, the research is showing that it's a mere fulfillment of the law. Some of the authors have described this to be a box-ticking exercise. So, okay, are you doing CSR, which is mandatory? Yes. Do you have a CSR plan? Yes. So you tick the box and then you move that we are also doing CSR without really going into the substance of that which is being contributed by the company. CSR has less investment on environmental programs. This is general, has been seen. And of course, there is a narrow interpretation of the stakeholders concept under the CSR. So we would want to see a more broader interpretation of what stakeholders are in a company. This has not appeared. This has not appeared. The legal framework, I will say that there is no general law on CSR for all companies, of course, as elsewhere. But the large part of CSR of companies is unregulated, the large part. The remaining part is based on a mix of soft law and hard law regulation. For the soft law regulations, or what we call private law regulations, the companies will come up with their policies, CSR policies, or they would adopt the internationally accepted or renowned CSR frameworks like the Global Compact, UN Global Compact 2000, okay? But of course, without really going into the nitty-gritties of the instruments that they adopt. This is common to the mining companies, which have shown widespread adoption of such kind of instruments. Like now, the reporting that they make, sustainability reporting from the mining companies, it's a very good report, but now when you go to the CSOs, civil society organizations and NGOs and scholars looking at it critically, it seems to be more of I would say greenwashing, what they call greenwashing or blue washing at the end of the day. So that's the thing. But on the hard law aspect, then you have the mandatory provisions under the Mining Act, that is Section 105, and then you have Section 222 of the Petroleum Act on 2015. So the companies which are in the mining area and in the extractive area, they're supposed to have CSR plans. This is a legal requirement that every year, it's a plan that is annual plan. They must have a plan that has been approved. This has also issues and implications at the end of the day, because the plans, if you are planning for a long term and you are planning every year, and of course there are no mechanisms other than saying you have to have this plan, but of course following on the plan, proving that that which has been provided in the plan has been done is still problematic. No reporting, no specific reporting mechanism, for instance, even in respect of this thing that we call mandatory CSR. So at the same time, there's a mandatory CSR reporting which exists under another separate scheme under the Tanzania Extractive Industries Transparency and Accountability Act. I just call it TEITA. This is a reporting mechanism, but of course only for the extractive industries companies. Section 15 of that particular law require reporting, but of course, without again providing for the items to be reported on, as well as the consequences of not reporting. So so if at all, when we want human rights to be promoted by corporations through CSR, then certain legal reforms have to be made. In the first place, the Companies Act is a very important statute that needs a lot of reforms so that CSR may be recognized. CSR in this particular context needs a Companies Act that gives a mandate for the company and a requirement for the companies to do CSR. In the first, as we speak today, there's no provision in the Companies Act on this particular aspect, not even mentioning CSR, not even mentioning what if you go to use colloquial terms, then perhaps using sustainability reporting or reporting on environmental aspects or reporting on the ESG, economic, social, and governance issues. There's no such kind of provisions. So the first thing that perhaps we need to improve that. And again, if that does not work, then in the alternative, the soft law or private law regulation aspect should be improved in this particular case. There has to be provisions in the law that require the companies to report on their CSR, to report mandatory to report on their CSR. You're not imposing it as a mandatory CSR, but you're imposing a mandatory reporting requirement. The CSR policies that we have should be regulated in terms of the content. Everyone is doing CSR, but what is the content of your CSR? It differs a lot from a company to company. The themes are not known. The reporting themes, just people are reporting on what they think that is going to be convincing on the society. So this will take us away from the tokenism, because if I do it voluntarily and I decide to put my items that I want, then I also report the way I want, and that perhaps makes no sense. Sure. So at the end of the day, then we need reforms in those areas. Then again, for a properly coordinated CSR, meaningful CSR, we need an institution that promotes, that coordinates, that monitors, evaluates, and perhaps also ensure that there is enforcement of those promises that we have in the CSR, in the CSR policies. If you are saying that you're committed to human rights, then we should see the way we can make you responsible at the end of the day. If you use the international kind of system, it's more problematic. It's more problematic. And so even where you have adopted, for instance, the UN Global Compact as your framework for CSR, the question comes into how do we enforce this? Because that is a merely a voluntary instrument. How do you enforce that? You go to the international human rights conventions, and you don't have a way that you can bring corporations into liability for human rights. So, well, the recourse, therefore, I think the national laws in this particular case, the municipal laws, have an upper hand then, therefore, to come in a country like Tanzania and make sure that that which is promised as CSR is done and it's enforceable at the end of the day. And also that which is reported is true. Okay, there are sometimes when one, as I said, you report very well, but of course, in actual sense, it's just a greenwashing. You're just trying to show that you're doing much, but at the end of the day, you're not doing much. So, well, I could talk and talk and talk, but of course, I think I should end up here to allow some discussion. I'm sorry if I exceeded the time. Otherwise, thank you for your attention.
Thank you very much, Doctor. It was very insightful. My take is that there is no general CSR normative framework in Tanzania, and more and mining and extractive companies are more having a mixture of soft and hard laws in terms of regulation. And you've also highlighted that there is no institutional legal framework, and you advised both the normative and institutional framework to be put in place so that CSR practices could be monitored and coordinated in a more sustainable ways that could benefit the companies, but also the government. Thank you very much. I will now introduce our next speaker, Professor Dr. Judith Schönsteiner. She studied her MA in political science in Mainz and Strasbourg between 1998 and 2003, and she received both her LL.M in international human rights and her PhD in law from the University of Essex. Since 2009, she lives and works in Santiago de Chile, where she's an associate professor at the Law School of the Universidad Diego Portales and member of its Human Rights Center, which she directed between 2012 and 2017. Her research focuses on economic regulation, business and human rights. She has worked on human rights obligations of state-owned enterprises, which was a project funded by the Chilean Foundation program, and was in charge of the National Baseline Study on Business and Human Rights in 2016, commissioned by the Danish Institute of Human Rights. Between 2014 and 2016, she was a member of the Presidential Advisory Commission on Persons with Disability. She has also researched on the institutions and procedures of the Inter-American System of Human Rights, the ILO Convention 169, on indigenous and tribal peoples, interpretation and incorporation of international human rights law in Chilean constitutional law. Since March 2019, she's a member of the independent expert panel of the selection of commissioners and judges in the Inter-American system. It's a real pleasure to have you here. And she will speak about the Chilean initiatives for obligatory standards of human rights for enterprises. You are very welcomed, and you can unmute yourself and share your presentation.
Thank you so much, Angela, for the presentation, for the invitation as well to all the organizers. It's a real pleasure to be with you. And I don't have a presentation with slides. I'll just want to talk a bit about the initiatives that exist in Chile regarding obligatory measures regarding business and human rights. Mainly based on recent developments, on some work we have been doing with the Chilean platform of civil society on business and human rights that I'm a part of. And certainly the research I have conducted on supply chains and state-owned enterprises recently. You will wonder why we would want to talk about due diligence laws in Chile if there's not even a bill regarding that yet. There are bills in Brazil. There is a draft bill in Peru. Well, Chile has not yet won. But a bill or a draft bill on due diligence, human rights due diligence and enterprises is part of the program of President Boric. It's mentioned there. He took office in March of this year. And the question now is what could be done regarding this? Besides NGO requests, there has not been too much debate on it, but there have been developments, interesting developments recently that go in the same direction. So I want to share with you a little bit what that is about, and then leave it to discussion to all of us whether a bill in the end is the right way, or if it's other measures that we could also explore to get to the same aim. I think an important issue here is that while Chilean companies have mostly traditionally looked at CSR as a tool or kind of method headline to deal with environmental issues, it's not anymore like this. They have understood that the ESG framework, environmental social governance issues in enterprises, is more comprehensive, and that CSR is not able to account for the response that companies have to do regarding regulatory requirements, and that it's less able than ESG and even a human rights framework to connect in the end what they do on that side of compliance and what they do on, let's say, philanthropic initiatives. So I want to focus my talk on human rights with a human rights focus and connect it to the ESG framework. I think it's interesting to look briefly into the human rights impacts we have in Chile by enterprises to understand what we would have to look to regulate. We have the typical impacts that mining has. We have a lot of copper mining, some gold mining, and lithium mining. Very recently, very important because of the electricity, transportation, e-mobility, and all the batteries we need for that. This goes along with the huge necessity of energy generation that Chile wants to change to renewables in the next decades. We had a coal boom after the 2000s, early 2000s, that we maybe should have not engaged in, but we now have to reduce coal. And are on a pretty good way on that through state policies and private investments. We have huge impact in agriculture regarding pesticides and water use because we are in a 10-year drought, and Chile is one of the countries that will have the heaviest impacts of climate change because of the droughts in the next decades. They're saying Santiago will run out of fresh water in 2030. And that's a huge issue because 80% of our water resources are used by agriculture. But agriculture gives us food as well. So yeah, we have to think about that a lot. There are impacts in salmon farming, pollution, mainly of the sea, forestry regarding indigenous communities and territories, and also water and pesticides. And there are two main transversal issues that don't allow Chile up to now to get to grips with the impacts and prevent them, as the guiding principles on business and human rights would require. And this is that we have weak oversight bodies of sectorial industries and also weak environmental oversight bodies. This has to do mainly with weak financing, especially for the environmental oversight body, but also with the nomination procedures and the lack of reduction of conflicts of interest. We're a small country. You need specialists to do the oversight. and to do all the measurement, etc. But these experts very oftentimes come from the private sector and go very soon, after 3 months, back to it. And that's not giving us the ability to have independent oversight bodies that would also look at issues impartially. That's a huge issue, and that leaves us with many issues ending up in tribunals, because the oversight bodies can't get to grips with it. And we have, in general, insufficient or absent territorial planning, which means that a lot of contamination happens exactly where it shouldn't happen, close to housing or close to protected areas, environmentally protected areas. There are also impacts of Chilean in companies abroad, and they have been documented especially by a Peruvian NGO, because Chilean investment is mainly Latin American investment, and retail, banking, and mining are operating abroad. And they found problems of compliance with law, but also absence of ESG policies in the companies, the Chilean companies that go abroad. And one of the main reasons why a well-thought due diligence law would be useful is to think also about this Chilean investment and economic activities abroad. Because as happens in Europe, where we are thinking about due diligence laws and they have been adopted a lot, there's the directive of the EU. In the moment companies go abroad, we have to think more transnationally, because national laws will not do sufficiently just on their own if they are not well coordinated. In general, I would say such a due diligence law needs to focus on issues of access to justice and prevention. And these issues of access to justice in most of the Latin American countries do have to do with gaps in regulation. But in Chile particularly, maybe the gaps of regulation are not even that big. The oversight problem is bigger, I would think. Our national baseline study showed that we had quite decent regulation, but that it was not actually implemented as it should be implemented. And we don't have legal aid systems, or at least in Chile, we don't have a sufficient legal aid system that would allow people who are affected by companies to demand their rights effectively. That's a lack of state aid, state legal aid, but also obviously, if we have a pro bono system that is mainly working with law firms that advise companies, then it's very difficult that these same law firms then do pro bono work. And they rightly say, no, we have a conflict of interest. And that's not solved yet. At the moment, it's law clinics in law schools and NGOs that do this litigation work, and it's just not enough to represent all the people who have been affected. If oversight bodies worked better, we wouldn't need to litigate so much. So I think there has to be a global approach to this. Just a brief word on national action plans, because it's been often discussed as a means to avoid litigation, but also to avoid due diligence laws. Our 2 national action plans are very, very weak in content, and they would not serve for what we need in terms of binding regulation. What is interesting, though, is that the 3 very interesting initiatives we have in binding legislation have not been in these national action plans. They have been generated outside this procedure, and that gives me some hints that we could improve maybe even different aspects without, even if we didn't manage to have a full draft bill on a due diligence law. First, we have an obligation for companies that are in the stock market in Chile to in the end report from the next year onward on human rights commitments, and they have to publish that. have to publish their sustainability reports, and they have to take a human rights approach to this, oriented by the guiding principles and by the guidelines of the OECD. So we will see next year how this works out, if it's well done. I have the suspicion that there is a lot of greenwashing to come up, as we heard in the previous presentation, but maybe the publicity of the reports will help us to show better what they should actually report and what they should improve. Our public procurement law has a regulation that if someone is fined in our working, in our directive of work, it's the oversight body for labor rights. If you're fined there, you cannot contract with the state for 2 years. And that could be expanded to other human rights violations and environmental violations. So if you have a fine, for example, in the environmental oversight body, you might get the 2 years bar. That can right now be included in any licitation, in any state licitation, in any state contract for public procurement. Some offices do already do that, some bodies do that, others do not yet do it. And for labor, it's the only one that is in the law. So if we move that from contracts to law, maybe we could have an important impact regarding concessions and public procurement. And finally, there could be some test litigation regarding consumer laws as well, because we have the possibility to complain about products that are not sustainable in environmental and health terms. And that would be maybe but we need test litigation for that to see whether it works. The first two ones, the one on reporting and the one on procurement, I think are very interesting initiatives to be broadened in the near future. Much easier to do than a law, but obviously not a replacement for a due diligence law that we do need, but don't know when we'd be able to do it because of all the other challenges our country faces right now. Thank you.
Thank you very much, Prof. It was very informative, and I noted that same as Tanzania, Chile has not yet a legal framework, and obviously also it lacks an institutional framework, and this lead to the certain violation of human rights. And you advise that a global approach should be taken with a more oriented human rights approach in addressing the CSR matters from a legal perspective. Thank you very much. I will now introduce our third speaker, Dr. Christian Ullmann. He has been a senior research assistant and since June 2020. He's senior research and assistant and also postdoctoral fellow at the Institute of Comparative Law, Conflict of Laws, and International Business Law at Heidelberg University at the chair of Professor Kuhn. He passed the first state examination at the University of Maine in 2012. This was followed by his legal clerkship at the Regional Court of Maine. Subsequently, he was a research assistant and doctoral student at the Institute for Comparative Law, Conflict of Laws, and International Business Law at Heidelberg University. During his LL.M. studies at Cornell Law School from August 2019 to May 2020, he received his doctoral degree in January 2020 with a dissertation thesis on the protection of investors and depositors in capital market and banking supervisory law. I would like now to welcome Dr. Christian. He's going to present on corporate social responsibility in Germany and the USA fundamentals and recent trends. You are most welcome. You can unmute yourself and share your thoughts.
Thanks, Agni, for the excellent presentation. I first try to share my PowerPoint presentation, and I think you can all now see my presentation. And yes. Yeah, thanks again, dear fellow colleagues, and thanks again for a lot for the organization and for having me here. Yes. Nowadays, which is at least my humble impression, the phenomenon of corporate social responsibility has become more or less pervasive. However, if one has a glimpse at the past, things have not been that clear as they are today. Having this in mind, and given the limited amount of time, I want to start right away. But first, I want to share with you the structure of my talk. For reasons of time, I leave out the very interesting first point, the Americanization theory, and I will then shortly start with the second point, shortly presenting the roots of CSR in the US, ending with recent developments and trends. This is followed by a similar discussion with respect to Germany. Lastly, I will draw a conclusion, thereby giving a short outlook on future trends and obstacles that come along with capitalizing private corporations for public ends. Then, what are the roots of CSR in the US? It all goes back to the question, in which interest should the corporation be managed? Should shareholders' interests prevail, the so-called shareholder value approach, or should concerns of non-shareholder constituencies play a role in corporations' decision-making too, the so-called stakeholder value approach? In comparative corporate law, the US is commonly described as an epitome of the shareholder value primacy. This dates back to the famous Dodge v. Ford decision from 1919. Its background is quickly summarized. The board of Ford, namely Henry Ford, wanted to share success with the public through price reductions, thereby explicitly subordinating shareholders' interest to those of consumers. However, this business decision was struck down by the Michigan Supreme Court. The court ruled that directors have to advance the interest of the shareholders, rather than in a charitable manner for the benefit of the corporation's customers. So, what is the end of CSR in the US, and where are we today? First, one has to take into account that many states enacted so-called constituency statutes. These statutes, simply speaking, allow directors but do not contain a respective obligation to balance the interests of non-shareholder constituencies, like the interests of consumers or employees, against the interests of shareholders in setting corporate policy. However, this does not apply to Delaware, which is of special importance because most big companies are incorporated in Delaware. In a 2010 decision, the Court of Chancery of Delaware confirmed this shareholder value primacy, holding that directors have to promote the value of the corporation for the benefit of its stockholders. This conception is also shared by the then Chief Justice of the Delaware Supreme Court, Leo Strine, who stated in a 2015 article that directors have to advance shareholders' interests only. Not doing so would be committing a breach of fiduciary duty. Additionally, the reporter of the draft restatement on corporate governance, Edward Rock, shared this opinion, stressing the promotion of shareholders' interest as paramount. According to this understanding, the concerns of non-shareholder constituencies are protected through other regulations distinct from corporate law. This, however, is not the full picture. In this regard, 2 points have to be mentioned. First, in January 2018, Larry Fink, CEO of BlackRock, in his annual letter to CEOs of corporations in which BlackRock invests, announced, among other things, that companies must benefit all of their stakeholders, including shareholders, employees, customers, and the communities in which they operate. Second, in August 2019, this was followed by the statement on the purpose of the corporation of the Business Roundtable. Simply speaking, the statement stressed the importance of stakeholders' interest. Shareholders' interest should not be paramount. So what can we make of this? In this regard, I want to stress that firstly, it should be highlighted that to my knowledge, there are no statutes in Delaware or on the federal level empowering directors to advance non-shareholders' interests. In contrast to Europe and Germany, respectively, there are no CSR reporting obligations too. Therefore, the question whether directors may consider stakeholders' interests in the course of corporate decision-making is more an issue of private initiative than of so-called hard law. And by the latter, I mean statutes and court rulings. Also, secondly, the language of the reporters of shareholder primacy sounds quite explicit, which applies in particular to the Dodge v. Ford decision. Things have never been as clear as one might think. To start with, in US corporate law, directors have always enjoyed a broad discretion regarding business decisions. This also entails the freedom to decide whether they strive for short-term profit or whether they focus on the long-term well-being of the corporation. Against this backdrop, directors are acting within their mandate as long as they can justify that respective investments are in the long-term interests of the corporation. One could even go so far to say that just a plausible reason is needed for directors to avoid liability. Therefore, even the principle of shareholder primacy gives a lot of leeway for directors to advance the interests of non-shareholder constituencies. Now, let us switch over to Germany. Regarding the initial question, in which interest should the corporation be managed, things look quite different. First and foremost, jurisprudence and most scholars favor stakeholder value over shareholder value. And this irrespective of the fact that statutes, like the German Stock Corporation Act, are silent on this question. Only the Stock Corporation Act of 1937, although a very dark episode of German history, entailed a detailed provision stipulating the dominance of non-shareholders' interests. Thus, in Germany, the board is not only free to consider the interests of non-shareholder constituencies, it is, to a certain extent, also obliged to do so. Therefore, management has to balance the interests of shareholders with the interests of employees, the general public, and other constituencies. However, as a minimum target, management has to ensure the general profitability of the corporation. Management shall also not subordinate shareholders' interests to those of the general public per se. Corporate spending on non-shareholder issues have also to be proportionate. When approaching the use of the term CSR in Germany, the discussion can be traced back to two developments. First, as the concept of CSR spilled over to Germany from the US in the years following the financial crisis in 2001, from a legal perspective, it was mostly about rather technical issues. One example was the question if shareholder can force directors to pursue social goals by subsequently including respective CSR clauses in the article of association, and what kind of majority is needed. However, there were critical voices against CSR in general as well. The latter expressed the concern that directors might use the CSR label as a carte blanche to further their own preferences, which are only remotely connected to the long-term interests of the corporation's shareholders, thereby exacerbating the principal-agent conflict. A typical example of this was the donation of corporate funds to certain charitable organizations favored by management, but also to political parties. Second, the latest development of CSR in Germany is based on both developments on the EU and the national level. Thus, the EU showed up as a player deciding to enact CSR legislation. In this respect, the CSR Directive of 2014 has to be highlighted, introducing the so-called CSR reporting. From now on, major enterprises have to issue a non-financial statement containing inter alia information about the corporation's impact on environmental, human rights, and social and employee matters. According to the CSR Directive, Such reporting obligations are vital for managing change towards a sustainable global economy by combining long-term profitability with social justice and environmental protection. Additionally, after a major incident concerning a German textile company, the debate if companies can be held liable for the violation of human rights of their suppliers began to gain momentum. This eventually led to legislative activity on the national level and on the level of the EU. In 2021, this resulted in the enactment of the German Supply Chain Act, which was followed by a respective proposal of the European Commission in February this year, the so-called Corporate Sustainability Due Diligence Directive. However, in this respect, I am glad to refer to Veronica's talk that will surely give us more insights on this particular topic. After having some word on the developments in Germany and the US, it is time to draw a short conclusion. So what can we make of this? Apart from the fact that the German and European legislature are clearly more active than their counterpart in the US, we can constitute a gradual shift concerning the purpose of private corporations. Today, it is not only about generating profits and thereby increasing the benefits of the shareholder and contributing to state's revenue. Corporations, more specifically, their internal structure, are used for ends that are primarily exogenous to corporate law. Major business enterprises from now on also have to take a broad range of aspects in consideration, like respecting human rights in general, and in particular in supply chains and environmental matters. In this regard, it is quite warranted to ascertain that, at least to a certain extent, private corporations are more and more used for the furthering of originally public ends. This phenomenon has, at least to a certain extent, to my impression, necessarily to be accompanied by an increase of private law enforcement. This goes back to the insight that public bodies are inevitably overstrained with the task of ensuring a sufficient level of corporate compliance with CSR regulation. However, private law enforcement does not come for free. In this respect, incentives matter. But what does this mean for CSR regulation on the German and European level? First, the CSR reporting obligation does not come with hard sanctions. Companies, of course, have to comment on certain CSR matters, but then it is up to the shareholders and other constituencies to decide what to make of this. Thus, one can describe the reporting obligation more as a nudging law than hard law, thereby causing the risk of what I might call cosmetic compliance. Compliance without any actual influence on corporations' behavior. Second, the German Supply Chain Act fully relies on public law enforcement. This is particularly unfortunate because only shareholders are entitled to recession rights and derivative suits. And it can be doubted if they are subjected to sufficient incentives to enforce non-shareholders' interests. Therefore, without granting stakeholder a respective course of action, CSR regulation might well end as a paper tiger. And with this warning, I would like to end my talk and excuse for the few extra minutes. And thanks to all of you for your attention.
Thank you very much, Christian. It was very insightful, and thank you for sharing the development of CSR from both countries. And I noted that it came from the practices and jurisprudence that has triggered the establishment of the German Supply Chain Act in Germany, which our next speaker will deal deeper on it. Now, I would like to welcome our last but not least speaker, Veronica Thalhammer. She's a PhD student and her research focused on the Supply Chain Due Diligence Act and on the binding of companies to human rights. She's also a lawyer since 2021, and she's as well since 2020 a research assistant at the University of Bayreuth with Prof Gundel at the chair of Public Law, International and European Law. She's also a member of the Africa Multiple Cluster of Excellence, and she has done some publications on the Supply Chain Act. She's going to share her thought on the corporate social responsibility in German company law, the due diligence and reporting obligations under the Supply Chain Act. Veronica, you are most welcome. You can unmute yourself and share your presentation.
Thank you for your kind introduction, Einstein. I will try to share my screen now. Okay. Yeah, welcome. And I will talk about the due diligence and reporting obligations under the Supply Chain Act in Germany. Do you see something changing? Oh, no, now it's working. Okay, so first I will give you some insights about the background of this law, then I will summarize the content. Of course, I cannot go into detail too much in the shortness of time, and in the end I will talk a little bit about critiques about this law. So first, about the background of the Supply Chain Act. You can briefly summarize that, of course, the aim of this law is to improve the human rights situation in supply chains of German companies. If this really happens, or if this really works, we will see, and we will talk about it a little bit in the end when I give some insights about critiques. This law was passed by the German Parliament more or less about a year ago, and it will start on the 1st of January 2023, so in some months now. And it is based on the UN Guiding Principles on Business and Human Rights, or at least this is the idea where it comes from. So now let's come to the content. First, the question is, who is addressed by this law? And we have two sides of this question. First, it is only German companies basically that are addressed. So only companies that have a headquarter or an administration in Germany, for example. So abroad companies do not fall under this law. On the other side, there is another requirement. The law addresses only companies which have more than 1,000 employees. And for the first year, means for the year 2023, it also only addresses companies with more than 3,000 employees. So this is quite a high number, and part of the critique, because people say, or many people say that there can be a human rights risk in the supply chain, even if the company is really smaller than 1,000 employees only. So what human rights are addressed by this law? Actually, there's a list of many human rights treaties, international treaties. And I will not go into detail, but I can give you some examples. What is the content? For example, the law contains the convention number 138 of the International Labour Organization concerning the minimum age for admission to employment, so against child labor. Then it contains another convention of the International Labour Organization concerning forced labor, and also a convention of the International Labour Organization about the freedom of association. And there are other topics, for example, discrimination in respect of employment, or also the topic of equal remuneration for men and women. And another important topic is safety measures at the working place. and there are some others, but just to give you an impression. And apart from that, the Supply Chain Act also contains 3 environmental treaties, which are dealing with questions of the use of mercury, persistent organic pollutants, and also dangerous waste and how to deal with it. Now the question is, what do the companies, or what are the really the obligations of the companies? They have due diligence obligations, so they need to try to deal with these human rights in a certain manner, which means first they need to implement a risk management, and they need to analyze which risk they find concerning human rights and environmental topics in the supply chain. And further, they need to implement a complaint procedure. So any procedure that helps any affected persons in the supply chain to report if there is any problem or any risks of human rights violations, or even if human rights violations already happened. Further, if they find any risk of human rights or any violation of human rights, they need to implement preventive measures. So what can they be? It could be, for example, a contractual assurance from suppliers that the supplier will comply with certain expectations concerning human rights. Or also this could be a training for suppliers or a training for the own employees how to deal with labor conditions or something like that. Also, this preventive measures could, for example, be an audit in the local production or something like that. Further, if a human rights violation happened or occurred, the companies are obliged to implement remedial measures. This can be different kinds. For example, they can think about paying a higher payment for suppliers, so that the suppliers are able to pay their workers enough money, for example. It could also be, if it is a serious human rights risk or violation, then it could be a temporary suspension of the business relationship. And there are more examples on what they can do in terms of remedial measures. Further, the companies need to document all the risk analysis and all the measures they are doing, and they need to document it internally. And apart from that, they have the obligation to publish an annual report, which means this report needs to be on the website, and also it needs to be signed in at a specific authority. It's important to know that all these due diligence obligations are not like the companies need to do them once and then they're kind of ready, but they need to do it again and again. And every year they need to start a risk analysis again. And if they find new risks, they need to deal with them. So it's an ongoing process. Now, the next question is, in which part of the company or the supply chain those due diligence obligations are relevant? You have, or you can differentiate between different parts of due diligence. One part is the complaint procedure, and the complaint procedure must be created in a way that every affected person in the whole supply chain needs to have the possibility to report any problems, which means that in the own company, the complaint procedure must be implemented, but also, for example, employees of the direct supplier need to have the chance to report human rights violations. And also in the further supply chain, there always needs to be the possibility to report via this complaint procedure. However, the risk analysis is only obligatory in their own company and concerning direct suppliers, which means the company, the German company, which falls under the Supply Chain Act, does only have to look actively at the own area and at direct suppliers, which means if they do not know anything about risks somewhere in the area of indirect suppliers, they're not supposed, or they're not forced to do a risk analysis. And this is also one point or one aspect which is criticized quite often, because they kind of can seem like they can be blind on this point, because they're not forced to actively look at this part of the supply chain. In this topic, it is actually I think, in my opinion, it's important to have a good complaint procedure, because the complaint procedure can be the initiative to have obligations also to indirect suppliers, because only if they know about risks at the area of indirect suppliers, they need to become active. So this is one point which is a problematic point, I would say. Another thing Christian Ullmann, I think, mentioned already a little bit, is that there is no civil liability within this law. This means that the law does not force the companies to pay any compensation to the affected people. Of course, there can be the possibility that the company is liable, but not as under this law, which is expressly said within the Supply Chain Act. This means that only punishment fees, for example, are the sanction if you are not fulfilling the due diligence obligations. And apart from that, you can, for example, also be excluded from public procurement. Further, there are also many uncertainties regarding the interpretation of the law, which is at the moment quite a big problem, I would say, because even if a company tries to implement the law in a good way, they have many open questions and they do not know how to deal with them. One example is the question how to deal with the following situation. There are, for example, human rights treaties. For example, the freedom of association, and this treaty is not guaranteed in every state where a supplier can be. So some states did not ratify this treaty. So the companies in Germany ask themselves what they should do. So they need, on the one hand, to fulfill this, the due diligence duties, but on the other side, there is an aspect of public international law that is saying that you're not allowed to interfere in internal affairs of other states. So you have kind of a conflict here, and the practice will show how to deal with it. But at the moment, I can see that many companies have troubles with such aspects, which is, of course, I think the problem is that they need to document everything and need to do a lot, but in the end, we cannot be sure if it really helps to improve the situation if they do all this reporting and documentation and so on. So in the end, you can say, I would say it is going in the right direction, but we will see how much it really helps. And also, we are waiting a new directive from the EU. Christian Ullmann already mentioned it. And this directive will be a lot stricter than the German Supply Chain Act. So we will see if this improves the situation or makes the obligations even stricter. So this from my side. Thank you very much for your attention.
Thank you very much, Veronica. It was very, very insightful. My take is that the law addresses German company which has more than 1,000 employees, and this is even where the critics lies. Why why and how about other companies. And you've also said that it has a due diligence obligations, which comprise, among other things, a risk analysis management with some preventive measures, but also a requirement for an annual report, which has to go and done on a systematic basis. Thank you very much. And thank you to all our speakers. We will now go ahead and take some questions, and we hand over to Sven. I will only have to highlight that we have 20 minutes left before we close the session. Sven, the floor is yours. You can take up some few questions before we close the session. Thank you.
Yeah, thank you very much for the very interesting contributions and to the very good interconnectedness. I think we got a real full panorama because we see that the problems on all the continents are similar or in all the involved states. Really, I already got some first questions here, written ones. I begin with the written ones. Meanwhile, you see if you want to do oral ones or written ones. The first one is of our participant, Stephen Macau. He thanks for the talk of Daniel Shayo and asks Dr. Shayo, what is, in your point of view, what do you think is the influence of CSR on trade unions? Maybe this is a question we did not touch so profoundly. Trade unions and CSR. What are the challenges involved, and what are the opportunities maybe for trade unions, maybe to enter in this field or to get more rights in the companies? Or is it all gloom and gloom, asks our participant. Daniel, the floor is yours to contest this, to answer this. Unmute, please.
Oh, thank you. I can hear you now. Yeah. Well, I will answer it quite summarily. It's a very good question on the issue of trade unions. Let's start from the principle that a trade union is representing the employees, and employees have an upper hand in corporate social responsibility. So in particular, I would say under the law, if you go to the labor laws, the trade unions are a right actually to the employees. But now when we take it a little bit more into the CSR, I would say the companies are not only supposed to allow their employees to become members of trade unions, but also they are supposed to facilitate them, make sure that they are members and therefore they can fight for their rights or their whatever that comes to their side. So as CSR, you remember that CSR has 4 main areas, and one of the areas is about the legal responsibility. That first, obeying the laws or taking that which is under the law, and perhaps secondly now going into beyond what the law provides. So if CSR is actually mature, or if CSR is really taken into its position, then we see that trade unions are also gaining an upper hand. I don't see the trade unions getting, anything better if the CSR goes down, but they gain more when the CSR goes up in that particular respect. Thank you.
Thank you very much, Daniel. And we are quite full with questions here. Already comes the next. I think it touches you again, so we stay a little bit with you. It comes from Gif Maluka. He also thanks for your interesting talk. And he asks, how do we strike the balance where CSR is used as a cover for some human rights violations? Yeah, CSR as a cover for some human rights violations. For example, in Malawi, big corporate companies have built schools and drilled boreholes while they are deliberately bright in allowing child labor practices in tobacco productions. Yeah, so they do something, as you related as well, more as a cover, not to look good, but in reality they practice bad practices. How do you challenge this question?
Oh, thank you very much for the question. It's a really good question, but of course it's a big issue. It's not arising today. For the multinationals, I think it's a common practice that multinationals have had a very bad history with the human rights violations in the world. And even the CSR, if you look at it from the beginning when it started, it was for the multinationals who actually were the first spearheading the general idea of coming up with a better face. You remember the issues about the Nigerian oil companies, which had violated a lot of human rights. But of course, later they now come up with the programs to cover. Now, I think the solution actually now lie into having the law now regulating them. If you have a law in place, they cannot play with it. Today they can play with CSR because, as it was, we saw it just that as a voluntary thing. For instance, as I gave you the first example here, I said a company may have come up with a very nice kind of report, sustainability report, showing a lot of good things. But if you just go into the field and see what they have done, you see that you find out this was just a cover. But in other words, I think we should not forget to have laws which are really strict on the issues like, for instance, environmental aspects, and rely on the CSR, even where we are going to say we have good CSR, but still such other laws like environmental law need to be strengthened. The legal environment has to be really strict, and in a way that for the CSR, of course, having a law that shows or that covers issues of false reporting and greenwashing and like that would help. But otherwise, if you just leave it and say, let the people, judge themselves that this is a good company, that's where now you have this now coming up with showing up a good face while they are not good at all. People have even talked about what we call window dressing. I mean, you're showing people that you are doing this good, but you are not doing anything inside, it's just a cover up. So again, I think I still maintain that CSR has to be regulated to be meaningful. The law has to be really coming into terms with CSR. Thank you.
Thank you. Very clear position and argumentation. I think Stefan wants to react directly. Please, Stefan, you may unmute.
Yeah. Thank you, Sven, and also to Dr. Shayo. My question is, there seems to be not so much jurisprudence, on this issue of corporate social responsibility. More so in Kenya, from where I come from, there's not so much jurisprudence flowing from our courts. And does it mean that, this issue has been settled, or does it mean that the debate has been settled, because more and more scholars are coming up, the relationship of this SAR and, so many other aspects. So does it mean that, the debate is over? What is the case, from a Tanzanian perspective, Dr. Shayo?
Well, thank you very much for the question, but I don't know if you mean the debate in the sense of people opposing CSR or which kind
exactly,
of...
Exactly.
Okay, thank you. Well, you see, CSR is not very old in our jurisdiction. It's something that is actually coming up with the modernity. As I said, for Tanzania, it's just like 25 years or so, sorry, 30 something years, because 1985 we're talking about. So the courts in this particular case have not had the issues that directly deal with the CSR in the sense of saying the court deciding on CSR, but of course the CSR related matters, for instance, issues of environment, are in place, and of course there are issues that we need to consider. But now the court jurisprudence, as you're saying, is lacking. You did talk about Kenya, but I would say jurisprudence in Kenya, apart from the fact that there are no decisions from the court, the laws have already moved a little bit more than what is available in Tanzania. The Kenyan Companies Act, if you look at that, the section 143, and you look at section 655, subsection 4, they are talking about CSR, of course, in form of ESG, environmental, social, and governance, and in a form of non-financial information reporting. These are really supportive to CSR. So again, we cannot compare that to Tanzania, where the law is still silent even on these particular important aspects. But of course, as you have noted, it's right. The courts have not really got into questioning this particular issue because of, I think, the novelty, and of course, people are really continuing to confuse it with many other things. And of course, the lack of the law, the lack of the legislation in itself is what we say, the courts will say, we don't deal with things which are not in the law. So how do you fight for a right which is not to be, say, found in a particular law? So again, it speaks for why the courts are not really advancing this. Thank you.
Okay, thank you very much again. I go a little bit in the order. Antidius, I saw your hand, but because the ones in the chat were first, let me read out quickly those of the chat. And we open a little bit the region as well. I have one from Godswill Aguaitoro, and this goes more to Christian and Veronica, so we change a little bit the perspective. He asks, to the extent to which international law, as per international instruments and the likes, has helped to influence CSR in Germany, especially when we consider the fact that corporations are not necessarily subjected to international law. This question of the subject. Very interesting question. I don't know who wants to start. Veronica, ladies first.
Yeah, I can start, and Christian, Ullmann, if you have anything to add, you can go then. Yeah, I would say actually international law influenced the German Supply Chain Act a lot. I mentioned it only a little bit in the beginning that it is more or less based on the UN guiding principles on business and human rights. This is an international treaty which is actually not binding, but only soft law. But this UN guiding principles contain also a part, or it contains many obligations for states concerning business and human rights, but also one part is about which obligations the companies themselves should have. And actually this led then to a national action plan in Germany and in many other states as well. And in the end, it led to the German Supply Chain Act. And so I would say this was kind of the first, the first thing in this direction to bind companies to human rights. But of course, it is not like now, because of the Supply Chain Act, the German companies are subject to international law, but it is only that they are subject to German law, of course. But I would say indirectly it influenced it quite a lot. maybe Christian Ullmann, you can add something if you want.
Yes, I'm glad to add something, but perhaps from a very general perspective concerning CSR in Germany, where you, Veronica, did some excellent work on the German Supply Chain Act. I would also say that private initiatives concerning CSR in Germany are also pervasive. That does not mean that private initiative is only connected to the United States. And in Germany, you find CSR plans or programs or whatever you might call it in many corporations, especially in the big listed companies on the stock exchange. And thus, one could even go so far to say that the CSR directive was not that kind of a big change, because they were also like this voluntarily CSR reporting and so on. And I think the reason why all this CSR reporting, which is of course like this voluntary CSR reporting, which is of course influenced by international law, treaties, and so ever, was like first like reputational issues, but maybe also like a change of awareness, like this, or the human rights matter, environmental matters. This was not like that present in the German perspective when you go back like 10, 15 years. But nowadays it's more or less pervasive. And of course, now companies, they want to avoid like negative publicity, and they are connected. Oh, yeah, you're doing very bad things with your supplier, wherever. So that's a reputational issue. And of course, every management board is under the obligation to protect the reputation of the company, and thus it can then be held liable. But again, hard sanctions are still missing, and at the end, the question of enforcement, of course, remains. And as long as there is no clear reputational issue at stake, stakeholder have still no voice in enforcing, or have still no voice in corporate law. Thus, only shareholders more or less can enforce corporate law, or can hold the management board liable. So this enforcement issue still remains.
I also have something to say here. I mean, as far as the international companies or multinational companies are concerned, I would think that something needs to be done also still at the international level. Because I think there has been an attempt several times. At least we have seen attempts in the 1970s, 1980s, 1990s. The attempts for the international community to hold the multinationals responsible for violation of human rights because of the scandals that were committed by them in developing countries. These attempts also could be seen also in the year 2004, when there was an attempt for the UN Commission to come up with the norms on the transnational corporations and other business enterprises with regard to human rights. Of course, all these attempts failed because the multinationals, of course, for one reason or another, there happened to be a debate between the North and South, in the sense that the North saying no actually to hard laws or whatever kind of rules that are going to be hard on, these aspects, and the South saying, no, we need the hard laws for this particular case, because of course the violations were happening in the South. Of course, we saw the developments that went on until when we came up with the John Ruby, sometimes later, who came up with the UN Guiding Principles on Business and Human Rights in 2011. Of course, these guidelines are still not mandatory. I mean, they're still a kind of a voluntary instrument. So we're back to square one. I mean, I if we are to be serious on this, the discussions that have been, the norms that have been, fought for some time and they have failed when it comes to the adoption, should be thought again for this, in the sense that unless we have something binding on the multinational corporations, we still have a long way to go, if at all, wait on their goodwill on their adoption of such kind of voluntary instruments. Thank you.
Thank you very much. We have already on the list Kaitu, and then Antidius Kaitu was first. Then I have Chris Minor-Peter, and then Judith Schönsteiner. Yeah, still 3 people to make questions or comments. Then we look how we do wrap this up. Antidius Kaitu, please.
Yeah, thank you. Yeah, a big thank you to the organizers and the presenters. My question is very brief and very straight to Veronica and Christian. Thank you very much for the nice presentation. I want to know, does the German Supply Chain Act impose extraterritorial obligations on the German multilateral corporations? Probably to clarify it better, if the German companies violate human rights abroad, can they be prosecuted in Germany? Thank you.
Who wants first?
I think concerning the German Supply Chain Act, it is Veronica who is the expert. But
I can try if you want, and you can correct if you want. Did I get it right? That the question is if companies in the supply chain, abroad companies, can be held liable within the German jurisdiction? Or did I get it wrong?
Yeah. German companies.
German companies.
Outside.
Yeah.
Can the victims of human rights violations outside Germany bring disputes in the German jurisdiction?
Yeah. Okay, I see the point. So actually, this could be the case, but not because of the German Supply Chain Act, I would say, but because of general laws. Or yeah, for example, I don't know if you know about the KIK case. In this case, they tried to sue, or foreign affected people tried to sue the German company KIK because somewhere in the supply chain, they I think there was a fabric that was burned and many people died from that. And in this case, the affected people tried to sue the German company KIK within Germany. And actually, in this case, I think the German court, they, how do you say, they used Pakistan law and not German law. But this was possible. In the end, the problem was that it was too late. I don't know the right name. It is Verjährung in Germany. Maybe Christian, you know the
word. Limitation applied.
Yeah, exactly. The limitation was the problem. Limitation under Pakistan law, but it was in general it was possible to try to hold the German company liable. But the German Supply Chain Act does not change or improve anything in that point. So actually the German Supply Chain Act contains a clause that is saying under this law there is no material civil liability. So you can always try to sue them with other laws, but not with the German Supply Chain Act, which is quite, criticized quite often. So this is actually one of the most criticized points. And in the EU directive, there is at the moment at the draft, there is a point about civil liability. So it could improve the situation, but we will see if in the end, this is really in the directive or within the process, it will be weaker. I don't know yet, and we will see.
Yeah, I think I have not that much to add. Concerning international private law, in this respect, with respect to Europe, the so-called Rome II regulation applies, and in Article 4, Paragraph 1, Rome II regulation, the law of the place of the injury controls. That means if the injury happens in Pakistan, Pakistan law applies. And that's the reason why the German Supply Chain Act and the EU initiative or proposal, they are not going over this, they are not using this direct connection, but they are more or less stipulating compliance obligations which the parent company or the mother company has to comply with. And at least from the perspective of the EU proposal, like victims in like the third states, they have a right to enforce, or they can hold the parent company liable, but only because this parent company violates the compliance obligation, and not because this company, like down the supply chain, violate or commit a tort. That's why they do this, because of the Article 4 paragraph 1 2 regulation. They want to avoid that the law of the place of injury applies, and therefore they more or less go or take the way concerning and creating this compliance obligation.
Thank you very much. Judith, go ahead with your comments.
Thank you so much, Mr. Maina, for allowing me to speak first. I have another commitment later on and have to leave, unfortunately. I just wanted to say, as there was no question regarding Chile, I just wanted to take the opportunity to briefly mention the initiative on the binding treaty that is negotiated in the UN, because I think this is actually the only text that would include the criminal liability that was asked for when we thought about prosecution, as I understood the question that we heard before, because it would have an article on criminal, extraterritorial criminal liability, in addition to the civil one. And there are also some provisions proposing administrative issues. But this treaty is just in its third draft. It's negotiated these days in Geneva again, and there is very, very little hope that it would actually come to a text to be adopted and then to be ratified. The EU actually has for many years opposed the text and the process, and is opposing the current version of the text, saying that its directive will just replace what is needed in the end, or will provide what is needed regarding extraterritorial obligations. I would think it's not enough because it's not in line with the framework that also the Committee on the Economic, Social and Cultural Rights has drafted down in its General Comment 24. And for our region, the Inter-American Court of Human Rights has also interpreted extraterritorial obligations wider than the EU directive will most probably do. So that is also why we're so much thinking of improving national laws, because that would at least help that we have more access to justice in our countries if the investing countries do not act as when their companies come to our countries. And I think we certainly will not discard any way forward, but we cannot too much rely on what is actually drafted and created in Europe, because they will never reach the standard that the French law has, according to what I can see from the discussions right now. And that's why we have to think about other ways of implementing, going from the finance industry down to state-owned enterprises and the obligations that states themselves have under the treaties, because it seems so far away that companies will be liable directly in public international law that probably that is not a route to go down. That's just what I wanted to say, and sorry again for taking the word first. Sorry. And thanks to the organizers once again.
Thank you very much again for your flexibility and of having made it able to participate in this talk. So now we hand over to Professor Meiner Peter.
Thank you very much. My internet is not very stable, but I just have one comment. First of all, I want to thank all the presenters. The presentations have by and large been very, very educative. And as Dr. Shayo has explained, corporate social responsibility is relatively new in international law. But for the developing countries, I think we have a more serious problem of educating decision makers and the public about the existence of this avenue, although the law is silent and the politicians are desperate to get investments and therefore don't insist on provisions in agreements which might scare away the investors. I think we must insist that the small letters of the law during negotiations should be should be looked at very carefully, and insist on setting in provisions relating to corporate social responsibility in the process of negotiations without necessarily citing any law, but that is part of negotiations. So I would, one, say that during negotiations is the opportunity to insert provisions relating to corporate social responsibility. And secondly, we should not allow corporate social responsibility to be just an issue of academics. I think it is high time we should shout about this, shout so that the public knows what is there, so that the parliamentarians know what is there, and the public, through public education like in the media, newspapers, TV, radio, know that there is this avenue which our countries can benefit from. I thank you very much.
Thank you very much. I heard this very much as a wrapping up closing statement and not so much as a question. So I think for today, we declare our proceedings for concluded. I think we touched a lot of questions. If we did not get to answer them all, please don't be sad. And I think, as always, what we want to do with this talk is to bring scientists of all the parts together. We always think this talk could be a starting point, that you try to make international projects out of it. No, it's not the end point. Obviously, it's the starting point of hopefully something interregional which you can produce. Thank you very much from my side.
Thank you, Sven. Thank you to everyone. I hope you enjoyed the discussions, and we look forward to attend you for the next sessions. We will inform you in advance about the topic and the speakers. And thank you very much again. Enjoy the rest of the afternoon or morning, wherever you follow this presentation from. Thank you again and have a nice day. Bye.
Thank you very much.
Thank you.
Thank you very much.
Thank you, Prof. Thank you.
Thank you, thank you, thank you.